Welcome back, everyone. We'll go ahead and get started with today's webinar. I want to introduce our panelists today. Joining us from EM3 Law, we have Ajay Mago, the managing partner. Ajay is a corporate and technology lawyer with a focus on complex transactional and advisory matters. Because of his consistently high volume of complex transactional engagements, he has developed a broad vision of the issues that confront business organizations and an aptitude for developing novel, creative, and constructive solutions. Ajay is a nationally recognized lawyer, a trusted boardroom advisor, and passionate advocate for individual, corporate, and institutional clients across numerous industries. His legal work has been recognized in the Washington Post, the India Business Law Journal, Law 360, Inside Counsel, Legal 500 US, Leading Lawyers for M&A, Middle Market, and other publications. He has handled pro bono matters involving international and domestic microfinance, civil rights, immigration, and other countless issues. Today, he's going to be talking to us about a lot of the legal challenges that are stemming from businesses that maybe have a variety of contracts and clients, potentially locally or internationally. And given the disruptions that we've been seeing in business, the disruptions to supply chains affecting production, some of that is obviously triggering contractual provisions, and Ajay will be talking to us about how businesses can be thinking about those provisions and handling those. Also joining us today, we have Therese Connolly. Therese is a partner in Barnes and Thornburg LLP's Chicago office. She focuses her practice in the area of domestic and international labor and employment law. She's a trusted advisor to her clients with over a decade of experience advising and counseling multinational corporations and navigating the wide range of employment-related issues that arise when managing a global workforce. She has over a decade of experience practicing in the area of domestic and international labor law and employment law. And she has worked in a wide range of industries in Asia Pacific, Europe, the Americas, Africa, and the Middle East. And she spent over a year practicing in the Tokyo and Singapore offices of Baker & McKinsey. She teams up with in-house counsels, human resource professionals, senior management, compliance and risk professionals, as well as others, and provide solutions to employment issues triggered by domestic and cross-border transactions. So both of these lawyers are very experienced and well-versed in their fields, and I'm sure they will be able to provide you with a very good understanding of how you can approach your situations that you may be facing. I do want to make one note, though, and that is that even though we do have two very experienced and licensed attorneys, nothing that is presented today should be construed as legal advice. We recommend that you learn from this webinar and then take those questions to your own lawyer, to your in-house or outside counsel, and clear it with your own advisors before acting on this advice. So with that, Ajay, I'm handing it over to you, and I will come back to field questions with our panel mid-program. Thank you.
Thank you, Neil. Good afternoon, everyone. Thank you for that kind introduction. I want to thank the U.S.-India Chamber of Commerce of DFW for putting together this series of webinars to help the Chamber members and the greater Dallas-Fort Worth business community weather and respond to the COVID crisis. And thank you, Neil, Rachel, Raj, and the rest of the USICOC team for inviting us to share with you what we are seeing in the markets and to help in any way that we can. Because the COVID-19 pandemic impacts virtually all aspects of business, financing sources, transactions, suppliers, customers, and employees, we're going to cover a variety of topics, each of which would normally be its own webinar. We ask that you hold questions until towards the end of the webinar because we may already be covering that question later on. Also, we'll be available to members after this webinar to help answer any specific questions. Also, I want to note that as a firm, we've established a pro bono program to help businesses in our communities respond to COVID-19. We're extending pro bono consultations to 10 companies a month, at least through the end of this year. You can email us at covidprobono@em3law.com and let us know your name, the name of your company, and the nature of your questions, and then someone within my firm will get back to you to schedule a time to talk about your specific issues and see how we may be able to help. That address, again, is covidprobono@em3law.com. First, I thought it best to address the shelter-in-place ordinances that we're all seeing. So as you know, several localities in DFW and across the country have already or are putting in place shelter-in-place orders, while also calling out companies that are ignoring these directives. These orders are preventing workers not engaged in providing essential activities, working at essential businesses, or providing essential services from leaving their homes to go to work. However, there are actionable steps a company can take to ensure that a shelter-in-place law in their jurisdiction does not inadvertently block your employees from getting to work at their essential businesses. First, be proactive. Contact your state and local government officials to make sure they understand why your business is essential. If your product or service is truly essential, no government official is going to want to be blamed for inadvertently causing a shortage of that product. Note, many orders define essential businesses to include businesses that supply other essential businesses with the support or supplies necessary to operate. If your business falls into that category, you may want to have that business explicitly enumerated as part of the orders, rather than relying on a judgment call for this catch-all provision. To proceed, first you identify the appropriate officials to notify and make sure they're aware of your essential business. EM3 can help identify the appropriate officials at the state and local levels and reach out to them. Also, develop the message to be delivered as to why your employees should not be required to shelter in place, and draft language to clarify why your business and its supply chain should be exempt from shelter-in-place ordinances. Additionally, several businesses have repurposed their operations to come to the aid of the community in this time of need. If you are one of the businesses who can repurpose your operations to provide essential services, government officials should be made aware. Second, respond to state and local trade organizations like our chamber and their efforts to stay ahead of the curve on this issue when they ask their members for information supporting why their member businesses should be considered essential and exempt from shelter-in-place requirements. Make sure you include your supply chain in the response. Third, increase the likelihood that your suppliers will fall under the exemption for businesses that supply essential businesses by sending individual letters to each supplier stating why that supplier is necessary for you to operate your essential business. If, on the other hand, you are a supplier to an essential business, we encourage you not to wait to hear from your customer. Instead, ask your customer for a written letter on their letterhead signed by an officer of that essential business saying that your product or service is necessary to the operation of the essential business. In that regard, note that in addition to your suppliers, transportation companies who are downstream of your manufacturing process but are necessary for delivery of your products made by your essential business should also receive a necessary to operate letter. Fourth, communicate to your employees that their work is part of an essential business or necessary to the operation of an essential business. If this is done right, that communication can be an opportunity to build morale during these times. Such communication should also be combined with the appropriate training around social distancing and other requirements to minimize the risk of infection spread while delivering the product required of the essential business. Now, of course, if you are open for operations, that raises a host of issues on how to deal with your employees, customers, and the public. And those issues, such as what to do if an employee gets sick, need to be properly thought through and addressed in advance of operating. In the meantime, the healthcare community is working as hard and as fast as they can to care for everyone and figure out what this virus is and what it will do and how we will continue to mitigate and move past this. They don't often have the luxury of staying at home. So it's important as communities that we do our part. So we should all do our part to stay at home when we can, unless we should properly be considered an essential business. Now I'll touch on some topics related to financing. One of the largest practices in our firm is our banking and finance practice. Many firms tend to represent one side of the equation more heavily. EM3's practice, however, is approximately 50% borrower representation and 50% lender representation. Accordingly, we've been working with our lender clients to put processes in place to respond to the tightening debt market and volume of defaults expected. So we have good insights into how lenders are looking at the market in COVID-19 and the post-COVID-19 world. By that same token, we're helping our borrower clients be proactive and starting early to engage with their lenders to ensure that borrowers we represent do not fall into the wrong pile as lenders seek to enforce remedies and shore up their own balance sheets. Of course, as many of you are aware, lenders are working with borrowers to put in place 30, 60, 90-day deferrals, interest-only options, and other options. Those are obviously all great options, and I hope all of your lenders are engaged with you in taking those steps. The focus of this conversation, however, is what to do if your lenders have not already taken those deferral or other breather options. At the outset, I also want to note that the ability for lenders to exercise remedies at this moment is really limited. Even if a borrower had defaulted a month or two ago and the lender was in the middle of exercising remedies, there's not much that they can do right now. In many cases, there are no court hearings, or even if you're able to file and get a case number, you're not going to be able to get in front of a judge. Courts are shutting down across the country. The ability to exercise remedies as a lender under the UCC has also been compromised. So lenders, of course, are struggling in certain circumstances with the ability to marshal any assets without being able to get in front of a judge. Moreover, there is little or no market for certain assets right now, like restaurants, oil and gas, hospitality. We're all going to see a lot of opportunities for deals over the next several months. However, at this point, there's not many people that are going to be willing to step in and fund those deals and buy those assets. So that obviously limits some of the recourse that lenders can practically take. Plus, no lender wants to be subject to additional scrutiny during this time of crisis. No one wants to be a headline in the New York Times, X lender has exercised remedies, due to the ongoing pandemic. So I think also our regulators and politicians still have the mortgage crisis in the back of their mind when they think about how to react to the pandemic, and lenders who have been and will be the beneficiaries of stimulus packages and backstops. All of that being said, lenders are working through their loan portfolios and identifying and categorizing credits in preparation for defaults and exercising their remedies. It is going to become increasingly difficult for lenders to meaningfully manage the decisions they're going to have to make for different types of credit without some sort of triage or classification system. So it's important for borrowers to be proactive in communicating with their lenders to ensure that each borrower ends up in the most favorable position possible. With our lender clients, we've been thinking about ways to classify credits into essentially 4 different categories. The first category of loans are the periodic check-in loans. Those are companies with solid operations, solid credit history, companies that you would never expect to make a lender's watch list, but for COVID-19. So in this case, if you're looking at a heat map, these periodic check-in loans would, fall squarely within, a lender's green zone. The second category of loans are stress business loans. These are companies that are already struggling. They were in stress or distress. They've been in discussions with lenders around turnaround for months before the coronavirus was even part of our day-to-day vocabulary. These are viable businesses, but COVID-19 put them into jeopardy. And for these companies, lenders are viewing them on the yellow part of that heat map. The third category are the pre-existing default loans. These are companies that would have failed regardless of the pandemic. If the lender was being asked to fund those loans today, they would have never funded the deal, regardless of whether or not the pandemic was existing. And for those category 3 loans, these pre-existing default loans, we're looking at those as, the red part, the red zone of the heat map. The fourth category is a bit tricky. These are the wait and watch loans. It's tricky because they're going to be a subset of the companies in the first category, the periodic check-in loans that are the healthy companies, and also the second category of loans, which are the distressed businesses. And the challenge with these loans is that they were once healthy companies, but the market and the lenders are going to look and need to consider whether these companies can survive or are relevant in a post-pandemic environment. And it may be because of the industry they're in or the segment of the industry. It may be because of a current or future regulation change in which changes the dynamics of the businesses and how they operate. And it may be something as simple as basic consumer demand. Ultimately, this translates into whether certain businesses will remain as relevant as they used to. These categories of loans, if we're looking at our heat map, we would probably consider them somewhere between the green and the yellow. And on any given day or given month, they may actually move slightly to the left or to the right. When we talk about remedies and funding in this context, obviously, there are lots of things that I'm sure you're thinking about in terms of the menu of options for a lender. First of all, does a lender call a payment default between now and, April 15th if the borrower doesn't pay? Does the lender send a reservation of rights letter if it decides it's not going to call a default? If there isn't a payment default, but the lender is worried about the business, can it utilize a material adverse changes clause or material adverse conditions clause to claim or call a default? Should the lender continue to fund advances right now, or should it sweep accounts? And these are all remedies obviously short of their other remedies like putting a company into receivership or foreclosure or lawsuits or UCC sales, all of which are sort of, outside of the available remedies for lenders right now. But some of the other remedies, the sweeping of the accounts, the declining the fund advances, those are all within the lender's control and can be really accomplished, with the click of a button or, just the push of a button. With respect to MAC clauses, I did also want to mention that there's really not a lot of case law on the subject. We do have some work product that we can share, but ultimately most MAC provisions and most loan agreements were not drafted with something like the pandemic or coronavirus in mind. So it's definitely going to be a litigated issue, most likely if a lender does decide to declare an event of default on a MAC and then decides to sweep accounts or not fund. Every loan needs to be considered on its own. So with that backdrop, I want to provide some, recommended actions for each category, and then we'll lead off with the periodic check-ins. As we talked about earlier, the whole exercise of this discussion is to help you identify, where to focus your energies, because as things change, the decisions for lenders will become harder and harder. So if you as borrowers are just another loan in a lender's portfolio, that's not the right place to be. So for the periodic check-in category, these are again the green side of the heat map. The periodic check-in loans are where these companies were, they have really solid operations, and but for Corona, COVID-19, they're great companies. Banks are currently performing bi-weekly performance reviews to see if things have changed with the company, and and lenders are sending reservation of rights letters in connection with any type of current or future advances being requested by a borrower. As they conduct these biweekly reviews, lenders reevaluate where credit is and whether it should be moving to yellow or red or someplace in between within at most 30-day period. As borrowers, we feel it's important to be responsive to reservation of rights letters, inform lenders of the measures you're taking, to ensure covenant compliance and the reduced business and the new business reality. Be proactive and anticipate that your lender is reviewing your credit on a biweekly basis if you feel you fall into this category. On the wait and watch loans, these are loans that, where the lender needs to consider where the market moves over the next, call it 1 to 6 months to figure out if they're going to stay green and be strong businesses on the other side in a post-COVID world, or if the business is going to result in, this borrower and the loan being distressed. For those loans, we're seeing lenders conduct weekly reviews of the credit, as well as an overall review of the industry sectors that the borrower is residing in. We're seeing reservation of rights letters in connection with current and future advances. I often suggest to lenders that if you're going to send one of those letters and as a lender, they have a relationship with the borrower where it makes sense to reach out, that they go ahead and reach out to the borrower and let them know that it's coming. And so it's important that at that time, once you are made aware that a reservation of rights letter is coming, that you engage, with your advisors and make sure you're being responsive and addressing those issues before things start to go further south. So this takes us to the distressed business loans. This is in our yellow area. This is where lenders are really spending their time evaluating and identifying the defaults in their credit agreements already. And this is where borrowers will start to get detailed notice of defaults that might be subject to cure periods or enhanced reporting. Even here, borrowers with distressed business loans can get ahead of the curve and turn a bad situation into something salvageable, simply because the number of defaults and questions surrounding whether a lender is accelerating properly or not is going to be such a highly litigated issue because of COVID-19 and the issues that it's causing across the markets. So being proactive and responsive and sending tailored messages to your lender can avoid defaults, breaches, and then subsequent litigation. So the more careful and methodical you can document what your position is with respect to pre-default and default issues, the better you'll be in the future and beyond, both optically as well as from a legal perspective. Do you have a reasonable cure period or opportunity to cure? Are you providing additional reporting and detailed business budgets? Have you been able to cure or mitigate material adverse condition clauses? As mentioned earlier and consistent with the other categories, for this category in particular, it's even more important to communicate with your lender on a much more frequent timescale. Finally, it deserves to be highlighted and really repeated. Document all communications that you have with your lenders, even as follow-ups to your verbal communications. This will avoid those situations where a lender changes their mind as industry macros deteriorate, and the lender is no longer willing to honor a verbal commitment or assurance, and needs to shore up their own balance sheet. And these will be, highly litigated issues. Okay, so moving on to the pre-existing default loans, these are, again, the businesses that were failing and frankly would have failed irrespective of the pandemic. Here, lenders are already running their UCC searches and shoring up their collateral and documentation concerns and preparing for UCC sales processes and other remedies. For this category of loans, we strongly recommend conducting your own analysis of identifying your defaults, preparing new budgets, and starting to work with your lender on engaging an outside consultant to ensure that the lender has comfort on the ongoing operations of the company. Lenders are preparing and sending default notices and implementing acceleration suites. Of course, lenders are also forbearing, and again, document all communications. In all categories, if you haven't already done so, consider drawing down on all availability on your lines to ensure access to capital for your needs. Depending on the covenants in your loans, this strategy needs to be carefully considered and implemented to avoid inadvertent breaches. I have many additional topics I was hoping to cover, but I can see that I'm nearing the end of my allotted time. Just quickly, we're helping other customers address force majeure issues, both upstream and downstream in their supply chain. We're helping our venture-backed startups work with their venture capital partners and shore up their capital stacks. We're also helping our venture clients, our private equity clients, and our M&A clients on both the buy side and sell side, to help them either save or walk away from a pending acquisition or investment or capital call, and dealing with max and other contingencies to renegotiate terms. In many cases, we're able to get very significant and beneficial deal term changes. I'm sure the Chamber can arrange more webinars to address these topics another time. So if these are sound useful to you, I think you can email Neil at president@usicoc.org if these are of interest. So again, thank you for your time, and thanks to the U.S. India Chamber of Commerce for hosting this. And I'll now turn it over to my co-presenter, Therese. Therese and I were partners together in a prior life and continue to co-counsel together on a variety of client matters. Therese will provide an update on the Family First Act, address some frequently asked questions there, and highlight some updates that have come hot off the press from the Department of Labor overnight last night. Teresa?
Great. Thank you, Ajay. So yes, just a quick overview of what's going on in the United States, our status. As of March 15th, we had 3,487 cases. And then just 2 weeks later, we have 163,530 cases of the COVID-19 virus. So that you can appreciate the acceleration, and those are statistics from the CDC. President Trump extended the nationwide distancing until April 30th because social distancing and the proactive measures that are being taken actually work. We're seeing increased cases due to increased testing. Most of the jurisdictions are having success, in other words, flattening the curve, although I will give you a caveat that Georgia is projecting a peak on April 22nd. So what I'm going to focus on is the Family First Coronavirus Act. I'm just going to call it Family First update. And AJ's right, the DOL has been changing these frequently. So you have to constantly look back, including this morning. The best thing to go to is the www.dol.gov/agencies/WHD/pandemic, and keep checking it, because the updates, there's no notice of the updates. There are also fact sheets on the Family First Act, paid leave rights and requirements, that is also in Spanish now. The Q&As, which we're going to talk about because they were revised, the Q&As for the Family First Act were revised on the 28th, went through 59 questions, and as of this morning, they were revised again and go to 79 questions. So, and lastly, there are, on the DOL guidance webpage, you'll see that there are posters and FAQs about notice, and they've added a Spanish version of the poster. So let's start with the emergency paid sick leave questions. I'm really just highlighting, because I'm sure many of you have attended many of these webinars with all the basics. I'm just highlighting the most frequently asked questions on the Family First Act. All right, so the emergency paid sick leave questions. Let's talk about eligibility. So only have to be employed 1 day versus 30 or more for the expanded FMLA, family medical leave. And it only covers 2 weeks, up to 80 hours, so 10 working days. And you have to pay attention to the definitions of full-time employee and part-time employee. Full-time employee under the emergency paid sick leave is 40 hours of work. And that's distinguishable from other statutes like Obamacare, which it's 30 hours, right? Whereas part-time employees, it's anything less than 40 hours per week, working 40 hours per week. And it's notable that it's not a bank of time that gets carried over into a third work week. And if you're part-time, the way you figure out is you average the hours worked over a 2-week period. So if you work overtime in the first week, so say 50 hours, and then you only have 30 hours left for the next week. Again, the cap is your 80 hours. Now, the regular rate of pay under the Fair Labor Standards Act, it's important to make sure you pay attention to how those are calculated. The regular rate of pay includes non-discretionary bonuses. You have to make sure that you're calculating it correctly. For part-timers, you average the hours for over 2 weeks, but if you have an employee whose hours vary, so 1 week they take 20, the next week they take 15, the next week, et cetera, then what you do is you take the 6-month average of those 2 weeks to find what the daily average daily hours are. My most frequent questions being asked about the emergency paid sick leave is, if an employee is not sick, does not have to take care of children because schools are closed, but is simply too afraid to come to work, do they get paid sick leave? Yes, we have gotten that question over and over. And the answer is no. You have to qualify for one of the 6 reasons for paid sick leave. The first 3 being, remember, you have COVID, you've been quarantined by a doctor, or you're seeking a doctor's advice because you are sick, or you're caring for someone who has COVID or is quarantined, or schools are closed or daycares are closed. So even if the person has anxiety attacks, they're too afraid to come to work because they have anxiety attacks, it does not qualify for the paid leave under the new law. Maybe it's enough for a reasonable accommodation request for unpaid leave, but it has to be analyzed on a case-by-case basis. So another question, does paid sick leave run concurrently with expanded FMLA? If the reason for taking both leaves is to care for a child whose school or daycare is closed, then yes. Another question, can an employee be paid for 14 weeks? No. The emergency sick pay is 2 weeks, and the first 2 weeks of the expanded FMLA is unpaid. Then it continues for 10 more weeks, making it a total of 12 weeks of paid leave. So company sick pay and state sick pay. We get asked, can I take company paid time to supplement the family's first pay? And the answer is only if the company agrees. So then we get the, can an employer force an employee to take company paid time to supplement family first pay? No, the family first paid leave is in addition to company paid leave. The employee could use it voluntarily, both parties have to agree. How about, can an employer pay more for the family's first pay? Yes, it can, but it's not going to get an additional tax credit for that additional third. If an employee takes leave under Families First, does that count against sick leave under state law? And the answer is no. It is in addition to that leave. So the next area we get asked questions is reinstatement after leave. So generally, under both the Families First Act and the sick leave, employees are entitled to be restored to the same or equivalent position, and there can be no retaliation because they asked for or had taken leave. However, you're not protected from a layoff, which would have affected you regardless of whether you took leave. Make sense? So in the Q&As mentioned that, however, you can apply for unemployment. There's an exception for employers who have less than 25 employees, but you have to meet all of the 4 following not to reinstate employees. And it's actually a pretty heavy burden, especially for a small employer. In order to not reinstate, for those employers who have less than 25 employees, you have to show the position no longer exists due to economic conditions related to COVID-19. Show that, that the employer, you made reasonable efforts to restore employee to the position. The employer has to make reasonable efforts to contact the employee if an equivalent position becomes available. And the employer has to make reasonable efforts to contact the employee for 1 year, beginning either the date of leave started or 12 weeks after leave began, whichever's earlier. That's a really heavy burden. We will see how it all plays out. There's also the Families First Small Business exemption. We get a lot of questions about how does the Families First Small Business exemption apply for employers with less than 50 so that they do not have to comply. So businesses with less than 50 workers can limit the new paid sick and family leave obligations. The businesses are still required to provide up to 2 weeks of sick leave for employees subject to a quarantine or experiencing symptoms associated with COVID-19. The required showing is the employer must conclude that providing the leave would cost more than the company's available revenue, causing the company to cease operating at a minimal capacity, or that the loss of workers on leave would be a substantial risk to the company's finances or operations, or that there are not enough available and qualified workers to replace employees who are out on leave. So the DOL, small businesses need to document how they satisfy criteria. That is how they're dealing with it. People have asked, well, do we have to apply for this? How does it work? Nope. The DOL is just simply saying, document the information in your files, get it right, and we'll figure it out all later. Lastly, we get a lot of questions about healthcare providers and Families First. And you will see that even today's updates on the DOL website's Q&As for Family First have a lot of changes here. So definitely you want to go to the DOL website, look at the Families First Q&A answers, and the ones I'm talking about right now are answers number 56 through 59. 56 through 59. First, who is a healthcare provider who may be excluded by their employer from paid sick leave and or expanded family medical leave? And it's a very broad definition. Anyone employed at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home, home healthcare provider, any facility that performs laboratory or medical testing, pharmacy, or any similar institution, employer, or entity. Then it goes on to say anyone employed by an entity that contracts with any of those institutions, employers, or entities, institutions to provide services or to maintain the operation of the facility. Anyone employed by the entity that provides medical services, produces medical products, or is otherwise involved in the making of COVID-19 related medical equipment, tests, drugs, vaccines, diagnostic vehicles, or treatments. It's a lot. I'm still going. Any healthcare provider identified by the highest official of the state or territory, including the District of Columbia, as necessary for that state's or territories, or the District of Columbia's response to COVID-19, or in essence, to minimize the spread of the virus associated with COVID-19. The department encourages employers to be judicious when using this definition to exempt healthcare providers from the provisions of Families First Act. So basically, it's an admonition by the DOL that everyone should, quote, do the right thing. So with that, we have some time for questions. I cut out a portion of the first part of my presentation, so we'd have some time for questions. I will turn it back to AJ and Yo.
Thanks, Therese. And thanks, AJ, for that. So yeah, we have about 15 minutes for questions and answers. There are two ways for you to ask questions. At the bottom of the Zoom screen, there is a button that says Q&A. You can type your question into there. Alternatively, you can type it into the chat box and we can get those questions answered for you. AJ, we did get a question from one of our attendees, and the question was, is there a slide deck that they can view on the information you covered? And I think that question came through when you were talking about the kind of 4 different buckets of businesses and kind of where businesses are in that. And so maybe, is there somewhere you can point them to, or is there a slide we can get for them?
Absolutely. I'll send that over. Just let me know. Should I direct it to you and then onwards?
Yeah, and then we'll get it out to
Okay.
in our newsletter.
And this is Therese. I have a slide deck as well, but what I would say is my firm, Barnes and Thornburg, right on the website, it's btlaw.com. So Barnes and Thornburg, btlaw.com, has an entire COVID page dedicated to where you can click and get access to a bunch of resources. And because this is changing daily, it's a great place to go and get the most updated information.
Great. And AJ, you mentioned an email where people could reach out to you should they need any support. What was that email again?
Absolutely. That email is COVID pro bono, PROBONO, at em3law.com.
And that's for small businesses to get answers right now, right?
Yeah, we've started our pro bono program specific to COVID-19 to intake 10 companies a month, at least through the end of this year, in order to help them answer some initial questions that they may be encountering during this time.
Great. I'm going to just include that in there. And would it be okay with you if we include that information in our newsletter, just as a resource for small businesses that may be struggling right now?
Absolutely. That's the whole purpose.
Great.
Absolutely. Thank you.
So let me see. I've included both of those links in the chat box, which should have gone to all panelists and attendees. I hope you're able to see those from the community. Do we have any specific questions for AJ on the financial aspects of and financial considerations, or for Therese on the employment law side? AJ, I do have a question while our audience is potentially typing out their questions. You mentioned that there were different categories of businesses, and one of the questions I had was, how do you know if you were healthy before COVID? How can a business think through that decision-making process? Was I healthy before? Am I going to make it through, or was I teetering and I probably need to use this time to reevaluate where I'm going?
Oftentimes I think it's one of those things that sometimes we may not recognize, kind of just absent the need of recognizing it. In this case, it's really thinking about what your cash flow was looking like. Was it were your operations continuing upwards, or were your revenues in a downward trajectory? What your reports to your lenders were looking like, and what the tenor of that conversation was pre-COVID-19. The other way you can really get a sense is what is the lender doing at this point in respect of your credit? Are you falling into that category where you've already received a reservation of rights? What sort of tenor of those conversations is going on? And I think those are probably the best ways of understanding it, where you would fall in those categories.
And would their lender be the best person to kind of help them think through that if they have a banker or a line of credit or something like that?
I think it's a combination of folks. It's certainly when you're responding to the lender. Now, you just kind of keep in mind, I mentioned on a few occasions that there were going to be some litigated issues that will be coming up. And it's important when you make responses to your lender that you think through all of those issues, right? So if you're claiming, for example, if you're claiming there has been no material adverse change or no force majeure in effect on a contract with a supplier, but then you're claiming that the opposite of that with your lender, that could be problematic. So you want to think through your communications and what trigger points you use. So if your lender says, well, we fear that there's been a material adverse change in the condition of your company, that you think through how to articulate a response there. And so certainly I think counsel, your law firms can help in that regard. And then in terms of the financial metrics, those are typically outside consultants. Outside consultants are preferable to lenders because they start to feel more confident in the credit when they feel like they have eyes and ears involved with the company on a regular basis and is helping them make a objective decision. So I think it's a combination of those two.
Gotcha. So we have a question from our audience here. If you're an essential worker and the employer asks you to stay at the office location for other emergencies, are they obligated to pay you for the time that there is no emergency, such as an urgent care? So if they ask you to work from 8 to 5, but you only see one emergency and the hospital only pays you for treating the one patient, do they have the right to ask you to stay the whole day? So maybe Therese, is that a question for you or
AJ? My question, but I don't see the question.
It's in the Q&A box. I can put it in the chat box for you there.
Oh, let me see. Okay.
There you go.
So the answer is it depends, but medical office is doing this. Okay. The answer is it depends. I see the Q&A. But it depends. I need more facts, but more likely than not, if you are not able to leave the premises, you have to be paid. Again, that's a very high level, general, not having many facts in front of me answer.
Looks like we have a follow-up to that.
No, I don't think so.
Okay, thanks. Okay. Any other questions? Therese, can you give us some guidance on anything that you may have seen related to healthcare workers in general? I know this is a question that has come up more often than once, which is I'm a healthcare worker and I have concerns about my working conditions, and I don't feel like I'm adequately protected. What can I do about that? Or am I just at the mercy of my management?
Yeah, interestingly enough, I advise the employer, not the employee.
Right.
But
or you can take it, on the flip side of that,
right.
if you're an employer getting those questions, because some of the individuals on this call do run clinics. And so I know that there are, they may potentially have employees that are in that situation.
Right. So with respect to the Family First Act, it goes back to that first, question. First of all, that providers are going to be exempt from that. The healthcare providers are going to be exempt. So obviously, it is in everyone's best interest to protect your employees to the extent that you can. So assuming the employer is doing that, I mean, if the question is, I'm afraid, right? If that's the question, we're back to that first slide, which is if the employer's actively doing all they can do to protect you, and you are a healthcare provider that falls under the excluded from the sick pay and the expanded family leave, we go back to regular employment law, right? Which is you can't just not show up for work without a valid reason that is protected under the law.
Thank you. Any other questions on that? Or any other topics related to labor and employment or financing a business during this time? All right, well, we are nearing the end of the hour. So we will go ahead and close out our webinar for today. If you are not already subscribed to the USICOC newsletter, I encourage all of you to subscribe to that newsletter. You can get up-to-date COVID-19 related business information there. We send out 2 newsletters a week on COVID-19 resources and updates and news, law, and other information for small businesses to consider. And also in that newsletter, you can get an up-to-date listing of all of our webinars. We do have another webinar happening tomorrow. That webinar is going to be on tax implications and financial implications for businesses. That's being provided by my tax filer. And it's a Saturday session because we recognize that some of you run businesses Monday to Friday, and then Saturday may be one of the few days you have. So that's going to be on a Saturday. On Monday morning at 10 a.m., we're hosting Key Coker. Key is the president of BBVA Bank, and he will be giving us an update on the Paycheck Protection Program, as well as the other lending opportunities that are coming through banks during COVID-19. He'll also be offering tips on things that you can do in terms of working with your bank or lender during this time. So join us for that. On Wednesday at noon, we will be having a webinar on marketing, how you can start preparing your business from a marketing standpoint to come out strong on the other side of COVID-19. And then finally, we have a webinar next Friday on more legal topics, primarily for those in the hospitality and multi-tenant industry, and then also on wills and trusts, because that's been a big question for a lot of people. With the high infection rate, unfortunately, people are wondering, do I have my affairs in order in case I succumb to this illness? So with that, I want to thank all of you. I think Therese wanted to add one more thing before we close out, but I want to thank all of you from the chamber, and I'm going to hand it over to Therese, and then when she is finished, we will close out. And then if you want to listen to this webinar again, if you need to go back and review some of the tidbits, I also wanted to add that this webinar will be uploaded to the Chamber's YouTube channel. You can Google YouTube, and then in the search box, type USICOC. All the webinars are listed there, and you can join us for that. You can review all of the webinars, and this one will be uploaded this evening for you to access. So Therese, I'm going to hand it back over to you, and then thank you all for joining us. And Therese, it's all yours.
All right, thanks. And I'm sorry, I should have said this, it's been a little bit more clear. So outside of the Family First Act, you have your regular Americans with Disabilities Act and other laws that are applicable in the workplace. So let's say someone has a condition that would make being around, suppressed immune system, and therefore being around, if you're a healthcare provider who's around people who have COVID, you're at heightened risk. One could make the argument that you could ask for a reasonable accommodation, which is either to not work near people who have COVID or an environment, work from home, figure out other assignments you can take that would not put you at risk. And that's called a reasonable accommodation under the Americans with Disabilities Act. And that's just one example of how if someone has a reason that they can't be in that situation, they can work with their employer to figure out an answer.
Yeah, and I will reiterate that people should definitely be checking with their in-house counsel or their outside counsel before they make any moves on this front, just because so many different laws are triggered by various decisions made by businesses. So again, everything should be taken as something to be considered, but we recommend that you check with your own legal counsel before you make any decisions.
Right. Employment law is the alphabet soup of laws. So you've got every letter represented by a statute. Title VII, OWBPA, ADA, ADEA. Anyway, thank you so much. I appreciate it, and thank you all for your time. And have stay safe and healthy.
Thank you so much. Thank you all.
Thank you all
for joining us, and we will see you guys tomorrow or on Monday for our next webinar. Thank you, AJ. Thank you, Therese. We really appreciate that extraordinarily insightful information, and hopefully we'll have you guys back on in another couple of weeks, and we can continue this conversation with more up-to-date information at that time as well.
Absolutely. Thank you.
Thank you. And everyone, congratulations to AJ. He just had a baby girl, and we're super excited for him. So congratulations, AJ, on behalf of the
Thank you. Thank you.
Thank you all. Have a great weekend.